Hello, everyone. We are Ask an Advocate, which is a website based project created to help clients and service providers find information and resources about income assistance, disability, tenancy, and other income supports. The information provided in this webinar will, however, be applicable in British Columbia only. In this webinar, we will briefly discuss a few things. What is the Residential Tenancy Branch? What is the Residential Tenancy Act? How to start a tenancy? What is a tenancy agreement? Types of agreements, rights and responsibilities of tenants and landlords, how a tenancy could end, types of tenancy notices, special circumstances that can end tenancies, and the dispute resolution process. Please keep in mind that the numbers discussed throughout this webinar are for the year 2021. Depending on when you are watching this, the ministry may have made changes since the time this video was created. Please check the description of this video and we'll be sure to keep updated links of any changes that may apply to this webinar. That being said, let's get the webinar started with the purpose of the Residential Tenancy Branch, which is also known as RTB. It is to help British Columbia residents get information and resources on tenancy and disputes. The Residential Tenancy Branch is a provincial body and it regulates tenancy laws as well as hosting hearings, making legally binding decisions, providing legal information, as well as online tools such as calculating rental increases and a ton more. The Residential Tenancy Act, often shortened to RTA, is the provincial act that applies to tenancy agreements, rental units, and residential properties only. There are, however, a few things that do not apply to the Residential Tenancy Act. Some of those include co-ops, commercial tenancies, emergency and transitional housing, accommodation owned or operated by an educational institution, accommodation where the tenant shares bathroom or kitchen facilities with the owner, as well as vacation or travel accommodations, correctional institutions, fixed-term tenancy agreements for 20 or more years, as well as community care, continuing care, and assisted living facilities. In addition to that, lastly, public or private hospitals. When starting a tenancy, the landlord gives the tenant the right to live on their property. In return, the tenant pays rent for the right to use said property. Both the landlord and the tenant sign a tenancy agreement, and the landlord must provide the tenant with a signed copy of the agreement within 21 days. There are multiple responsibilities that each party must follow when in a tenancy agreement, and some of these are as follows. So, the landlord must comply with BC rental laws, and the tenant must pay rent and fees on time. The landlord must make sure that the rental unit and building are maintained according to the health, safety, and housing standards. In return, the tenant must also maintain reasonable health and cleanliness standards of the unit. The landlord must make repairs and keep the unit or building in good condition, and in return, the tenant must ensure that their pets and guests do not damage the property. If the tenant's guests or pets cause damages to the property, the tenant must repair them. The landlord is responsible for paying the utility bills on time if they are included in the rent. The tenant must not disturb other tenants or neighbors. The landlord is responsible for investigating any complaints about disturbances, and in return, the tenant must not endanger the safety of others on the property. The landlord must make sure that the tenant's rights to quiet enjoyment and peaceful occupation is respected. In return, the tenant must ensure that the landlord and other tenants' rights are respected as well. Now, there is a few definitions that you will probably want to know in regards to the Residential Tenancy Act. So you'll often hear the term co-tenant. Now, co-tenants are roommates who share a tenancy agreement. There are also tenants in common, which are those who live in the same unit but have separate tenancy agreements. And lastly, there is an occupant or a roommate, which is someone who rents from a person or primary tenant rather than a landlord. So what is a tenancy agreement? Well, a tenancy agreement is a legally binding contract listing all of the terms and conditions that a landlord and tenant must follow. It must also include whether the agreement is month to month or fixed term, how much the rent is, what is included in the rent and when the rent is due, how much is the deposit, and lastly, guidelines on how to follow proper tenancy laws. Now, It is important to note that any terms deemed oppressive and grossly unfair on the tenancy agreement cannot be enforced by neither the landlord nor the tenant. Any term on a tenancy agreement that does not comply with the Residential Tenancy Act is actually considered to be unconscionable. So, for example, if a landlord writes that he will charge an extra $75 for having a friend stay over, he actually cannot enforce it since the Act states that one cannot charge a fee for overnight guests. There are, however, a few mandatory items that must be included in the residential tenancy agreement, and a few of those things include the legal names, addresses, and signatures of both the landlord and the tenant, the address of the rental unit, the agreement terms, the rent amount and due date, the services or facilities included in the tenancy, the security or pet deposit amount and its due date, the landlord's mailing address and phone number, as well as the date that the agreement was signed. A tenancy agreement must contain standard terms outlining the rights and responsibilities of both the landlord and the tenant. Few of these things would include pets, repairs, payment of rent, rent increases, locks, condition inspections, landlord's access of the unit, as well as occupants and guests. Please note that if you are in a situation where there is no written tenancy agreement, that the standard terms still apply and that the tenant is still covered by the Residential Tenancy Act. There are two main types of tenancy agreements, which are month-to-month and fixed term. In a month-to-month tenancy, there is no predetermined end date. That's to say that the tenancy will end only if one party gives notice. This type of tenancy is flexible, but it's often not stable, as the tenant can be issued an eviction notice at any time. A tenant, in turn, can also end a month-to-month tenancy by giving the landlord a 1-month notice. In a fixed-term tenancy, there is a predetermined end or renewal date. This type of tenancy is not flexible, but it is stable. A landlord cannot use a vacate clause at the end of the lease term unless explicitly stated at the beginning that him or an immediate family member will occupy the unit at the end of the term. There are consequences for breaking a fixed-term tenancy, such as owing the other party money for months left in the lease. A landlord can require a security and potentially a pet damage deposit. The two combined cannot be more than 1 month's rent, however. A landlord can also not request additional deposits for any additional pets you might have. So for example, if a tenant's rent is $1,000 per month and the tenant has 3 pets, the landlord can only ask for $500 for the security deposit and $500 for the pet deposit. A condition inspection is an inspection of the unit that is done to protect both the landlord and the tenant. The inspection should be done at a few different times in the tenancy. At the start of the tenancy, when the tenant gets a new pet, and of course at the end of the tenancy. Rent payment is considered late if it is not paid by midnight of the due date. A landlord does not have to reinstate the tenancy if the full rent amount is not paid. The landlord must also provide the tenant a receipt when the rent is paid in cash. A rent increase can only occur once a year and only by the amount permitted by law. 3 months before the rent increase occurs, the landlord must give the tenant a notice of rent increase form for the increase to take effect. For the year 2019, the rent increase amount is 2.5%, and for the year 2020, the rent increase amount is 2.6%. For example, if the landlord issues a rent increase on January 1st, it doesn't take effect until May 1st, since the month of January does not count. Other than the standard rights and responsibilities, there are rules that both the landlord and tenant must follow. The landlord must give a minimum of 24 hours and maximum of 30 days notice before entering a tenant's unit with a clearly stated date, time, and reason for entry. The landlord can only enter a suite between 8 a.m. and 9 p.m. unless the tenant agrees for a different time. The landlord may also enter a rental unit whether the tenant is present or not after having given proper notice, and the tenant cannot deny them access at this point. The landlord is allowed to conduct monthly inspections, and a landlord may enter a rental unit in the event of an emergency or when there is an order from the residential tenancy branch. A tenant is allowed to sublet their unit, which means that the tenant can temporarily rent their unit to someone else until they return. A tenant is also allowed to assign their unit to someone else, which means that the tenant can find someone to take over their tenancy. Both sublet and assignment must require the landlord's approval first, and not receiving permission may lead to a 1-month notice being issued. There are various ways that a tenancy can end. However, in almost all, the landlord or the tenant must give the applicable notice. When a notice is received, the individual must read the front and back, as it does provide important information on how to deal with the notice. All notices are time sensitive, so it must be dealt with as soon as possible. You may want to contact your local community agencies to get help with understanding and responding to the notice. For a month-to-month tenancy, a tenant can give a 1-month notice to their landlord the day before rent is due to inform them that they are moving out. So, for example, if a tenant is intending on moving out on November 1st and rent is due on the 31st of every month, then the tenant must give the landlord their 1-month notice on September 31st. For a fixed term lease, the tenancy can be ended when both parties sign a mutual agreement to end tenancy. It could also be in regards to the tenant is fleeing abuse. It may be ordered by an arbitrator, or a landlord or landlord's immediate family member intends on moving into the unit after the lease term ends. There are a few common types of notices that can be issued. A 10-day notice is given when a tenant hasn't paid rent on time or has yet to pay utilities in the last 30 days. A 1-month notice is given for a multitude of reasons. However, it is more often than not issued for behavior-based issues. 2-month notices are given to a tenant when the landlord or their immediate family member intends on moving into the unit. And a 4-month notice is given when a demolition, renovation, repair, or conversion of the unit is needed. Each of the notices has a deadline to dispute, so don't forget to address them as soon as you receive it. A notice is deemed received on the same day or multiple days after, depending on the way it's served. If the notice is served in person to either the landlord himself or the landlord's agent, it is considered received on the same day. If the notice is posted on the door, it is considered received on the 3rd day. If the notice is faxed, it's also considered received on the 3rd day. However, if the notice is mailed, it is considered to be received on the 5th day. The best method to serve paperwork to a landlord is on paper and in person. It's best to bring a witness with you when you're serving the landlord so that there is proof that the notice was served properly. A 10-day notice can be given when a tenant hasn't paid rent on time or has been issued a 30-day notice to pay utilities and the utilities remains unpaid. If the tenant pays the rent or utilities owing within 5 days of receiving this notice, the notice is automatically annulled and the tenancy continues. If the tenant disagrees with the notice, the tenant must apply for a dispute within 5 days of receiving that notice. Here you can see a 10-day notice. It is a 2-page document. There is a lot of information to take a look at. Feel free to pause the video now if you'd like to look a little further into the details. A 1-month notice can be issued to a tenant when the tenant hasn't paid the security or pet deposit within 30 days of moving into the rental unit. It may also be that the tenant is late paying rent at least 3 times or has caused illegal activities, excessive damage, they have sublet without the landlord's permission, and for other health and safety reasons potentially. The 1-month notice, as shown here, is also a 2-page document with a list of possible reasons why the notice is being served. The landlord must check off the appropriate reason for the notice to be valid and write a brief description of the cause. If the tenant chooses to dispute this notice, they must do so within 10 days. There are a few circumstances when a 2-month notice may be issued, and that can include that the landlord plans to use the property. It could be that the landlord or their immediate family member plans to occupy the unit. It could be that the landlord sells the property to a new owner and the new owner plans to use the property for themselves, or it's simply that the tenant no longer qualifies for subsidized housing. A 2-month notice is a slightly larger document coming in at 3 pages with a list of reasons on the 2nd page. The landlord must check off a reason for the notice to be valid, and the tenant has 15 days to dispute that notice. It is important to note that when a tenant is issued a 2-month notice, that one of those 2 months is free rent. A 4-month notice can be issued when the landlord plans to do major construction or renovation. However, for the notice to be valid, the landlord must have all necessary permits in place before giving the notice. If the tenant ends up being evicted but the renovations haven't occurred, the tenant could be compensated 12 months' rent. A 4-month notice is also a 3-page document with a list of reasons that may be applicable to the type of renovation that is required. The landlord must also write a brief description of the renovation being done. When a tenant is given a notice, the tenant must move out by 1 p.m. on the last day. The unit must be cleaned and the keys must be returned to the landlord. It is highly recommended that the tenant and landlord complete a move-out condition inspection. The tenant must provide a mailing address for the landlord to return their damage deposit to. The landlord has 15 days to return deposits. A landlord who does not follow procedure can be ordered to pay the tenant 2 times the deposit's worth. There are special circumstances that can end a tenancy for a landlord and tenant. There are special circumstances that can end a tenancy. This could include the death of a landlord or tenant. When a landlord or tenant dies before the tenancy is over, it is automatically assigned to the executor of the deceased person's estate. In the case of the tenant, if there is a co-tenant, then the tenancy is then assigned to that co-tenant. The executor will gain all rights and responsibilities of the unit and can decide whether to continue the tenancy or to give notice. A frustrated tenancy can occur due to an unexpected event wherein the original tenancy agreement cannot be continued. However, this cannot be through the fault of either the landlord or the tenant. So, for example, if a fire rendered the unit uninhabitable, then the tenancy could become a frustrated tenancy. If a frustrated tenancy occurs, the landlord may have to reimburse the tenant for any rent paid for any period of time after that unexpected event. Abandonment occurs when a tenant gives up the tenancy without proper notice. That is to say that the tenant has removed all their personal belongings from the unit and is not expected to return. Abandonment can also occur when the tenant informs the landlord that they do not intend on returning to the unit. Foreclosure, however, occurs when the landlord can no longer pay their mortgage and the bank has threatened to sell their property. When the tenant is fleeing family violence or is moving into a long-term care facility, they must provide the landlord with a 1-month notice and a completed ending fixed-term tenancy confirmation statement form. If the tenant has received an eviction notice and they have reached the stage to vacate the property but is refusing to leave, keep in mind that the landlord cannot physically remove the tenant. The landlord must apply for an order of possession, to which then a bailiff will remove the tenant off the property. When a tenant receives an eviction notice, if they believe that it was not given in good faith, they must apply for a dispute resolution within a certain amount of days. For a 10-day notice, the tenant has 5 days to dispute said notice. For a 1-month notice, you have 10 days. For a 2-month notice, the tenant has 15 days to dispute it, and for a 4-month, you have 30 days to dispute it. A dispute application can be submitted at the Residential Tenancy Branch, the Service BC office, or online. Please note though that the filing fee for a dispute resolution is $100. If an applicant is low income, the application fee can be waived by submitting the application to waive filing fee. The Residential Tenancy Branch will review the request and inform the applicant whether it has been approved or not. If the application is not approved, the applicant must pay the filing fee to continue the dispute resolution process. Once the applicant has received a scheduled hearing date, the applicant must serve the hearing package within 3 days of receiving it. You must also serve evidences to the respondent and the Residential Tenancy Branch 14 days before the hearing. Once the respondent receives the evidence, he or she has 7 days to serve this evidence. After the hearing has occurred, the arbitrator conducting the hearing has 30 days to make a decision. Generally, both parties are notified of the decision via mail or email. However, sometimes the decision is mentioned at the end of the hearing. When an applicant submits an application for a hearing, it can be classified as an expedited hearing depending on the situations. The reasons for expedited hearings are an order of possession for a tenant, requesting emergency repairs, or an early end to tenancies. The branch will try and schedule a hearing within 12 days from the date the application is made. In the event where the applicant can demonstrate that violence has occurred, health and safety were severely jeopardized, or that there is an immediate danger or threat, the branch may schedule a hearing within 6 days from the date of application. The application for the expedited hearing, as shown here, is a 4-page document. The applicant must explain on the application how they meet the conditions of an expedited hearing. The expedited hearing application has to be served within 24 hours to the respondent, and evidence must be served 48 hours before the hearing. Once a decision has been made after a hearing, the applicant or the respondent can apply for a review of the decision with the residential tenancy branch. However, this only applies if one of a few certain circumstances occur. So either a party has new and relevant evidence that was not available during the hearing, the party was unable to attend for good reason, or if a party believes that the other used fraud during the hearing. The residential tenancy branch may grant the party the review and will make another decision. If the residential tenancy branch upholds the decision, that is to say that they do not change their mind, the party can apply for a judicial review with the Supreme Court. Of course, I just want to take the time to thank everyone for watching. Feel free to browse through other webinars and provide us feedback by clicking